We begin with a question matching federations with their constitutional amending procedures. The correct answer, B, links the USA to state approval, India to ratification by half of states, Switzerland to popular initiative, and Australia to popular approval. The core constitutional provisions for amendment, under Article 368, grant Parliament the authority to amend. Initiation is solely through a bill in Parliament, and there is no provision for a joint sitting. The President must give assent and cannot withhold or return the bill. The Constitution provides three methods of amendment: a simple majority, similar to ordinary legislation; a special majority, requiring a majority of total membership and 2/3 of members present and voting; and special majority plus ratification by at least half of the state legislatures for federal matters. The Basic Structure Doctrine limits Parliament's power to amend the Constitution's fundamental features. Established in the case of Ananda Bharati case in 1973, key elements include democracy, rule of law, federalism, and the independence of the judiciary. Key landmark amendments include the 42nd Amendment, the Mini-Constitution, and the 73rd and 74th Amendments for local bodies. The latest is the 106th Act of 2023, the Nari Shakti Vandan Adhiniyam, reserving 1/3 of seats for women in the Lok Sabha and state legislative assemblies. The 131st Amendment Bill, 2026, which proposed increasing Lok Sabha seats, was defeated. Globally, amendment methods range from the UK's flexible system, requiring a simple majority, to the USA's rigid system, requiring a 2/3 majority in Congress and 3/4 state approval. The Australian Constitution is rigid, requiring popular votes and state majorities for amendment. India's process is mixed, requiring a special majority in Parliament and the consent of half the states for federal changes. The second practice question asks about the State Reorganization Commission members. The historical evolution of state reorganization started with the Dar Commission and the JVP Committee rejecting language as a basis. The creation of Andhra State in 1953 followed Patti Sriramulu's fast. The Fazal Ali Commission accepted language as a factor, leading to the 1956 States Reorganization Act. The States Reorganization Commission was chaired by Justice Fazal Ali, with members H.N. Kunzru and K.M. Panikkar. An important clarification is that Patti Sriramulu, despite his critical role, was never a member of the SRC. This question asks, which element is not part of India's secular state? The correct answer is B, taxation on religious property, as Articles 25 to 28 guarantee the right to freedom of religion. Articles 25 to 28 provide the right to practice, manage, and prevent taxation for religious purposes, and prohibit religious teaching in state-funded schools. However, these rights are not absolute and can be restricted on grounds of public order, morality, health, and social reform. The Indian federal system is based on the pattern of Canada. Key features borrowed from the UK include parliamentary government and rule of law, from the USA, fundamental rights and judicial review, and from Canada, the strong centre and residuary powers. Additional borrowed features include suspension of fundamental rights from Germany, fundamental duties from the Soviet Union, republic ideals from France, the amendment procedure from South Africa, and the, quote, procedure established by law from Japan. The philosophical postulates of the Constitution are based on the Objective Resolution. The Objective Resolution, moved by Pandit Nehru, laid the philosophical vision of justice, equality, and liberty. It served as a blueprint for the Constitution, which was passed on November 26, 1949, and enforced on January 26, 1950, transforming the vision into a structured legal framework. The preamble summarizes the Constitution's philosophy and acts as its identity card. It was enacted after the rest of the Constitution was finalized. The flow of creation was the Objective Resolution, then the detailed Constitution, and finally, the preamble. The salient features of the Constitution do not include a committed judiciary. The Indian Constitution is the world's longest written constitution, drawn from various sources, and exhibits a unique blend of rigidity and flexibility. It establishes a federal system with a unitary bias and an integrated, independent judiciary. Let's review two practice questions. Question 7 confirms that the directive principles of state policy were borrowed from the Republic of Ireland. Question 8 confirms that the doctrine of emerged from the Keshavananda Bharati versus State of Kerala case. The term basic structure is a judicial principle, not explicitly in the Constitution, designed by the Supreme Court to balance power. The core conflict was between Parliament seeking full amendment power and the judiciary seeking to protect the Constitution's core identity. The early evolution saw Parliament push for land reforms, leading to the First Amendment Act. In the Shankari Prasad case of 1951, the Supreme Court ruled that Parliament's power to amend includes fundamental rights. The conflict escalated with the Ninth Schedule shielding certain laws from judicial review. The Sajjan Singh case of 1965 initially upheld Parliament's power to amend any part of the Constitution under Article 368. However, the Golaknath case in 1967 marked a major shift, ruling that Parliament cannot amend fundamental rights. In response, the 24th Amendment Act of 1971 reasserted Parliament's power to amend any part of the Constitution. The Kesavananda Bharati case of 1973 was the landmark ruling, concluding that Parliament can amend the Constitution but cannot destroy its basic structure. We also confirmed that the concurrent list was adopted from Australia. The Seventh Schedule, under Article 246, details the division of legislative powers across 3 lists: the Union list with 100 subjects, the State list with 61 subjects, and the concurrent list with 52 subjects. Residuary powers are vested exclusively in Parliament, following the Canadian model. A practice question asks where the ideal of a welfare state is enshrined. The correct answer is the Directive Principles of State Policy, which outline the socio-economic goals of the Indian state. The welfare state is anchored in Part 4, the DPSP. Individual liberties are found in Part 3. Fundamental rights, justice, liberty, equality are stated in the preamble. Division of powers is defined in the 7th Schedule. Regarding Question 11, all listed items, relations between union and states, finance and property, trade and commerce, and fundamental rights are integral parts of the Indian Constitution. The Constitution is divided into 25 parts. Key parts cover union and territory, citizenship, fundamental rights, DPSP, fundamental duties, the union, and the states. Part 7, concerning Part B states, has been repealed. Other crucial parts address panchayats and municipalities, union-state relations, finance and property, trade and commerce, services, elections, official language, emergency provisions, and amendment under Part 20. Regarding Question 12, features not borrowed from South Africa are procedure established by law from Japan and center appoints state governors from Canada. Question 13 confirms the objective resolution was adopted on January 22, 1947, and later framed as the preamble. The objective resolution, moved by J.L. Nehru, sets the philosophical vision for an independent India based on justice, equality, liberty, and fraternity. Its core principles include a sovereign democratic union, total justice, equality, and protection for minorities. The Union List, part of the 7th Schedule, grants the central government exclusive power over 100 subjects of national importance. These include defense, foreign affairs, citizenship, railways, posts and telegraphs, currency, banking, census, and the constitution of the Supreme and High Courts. Moving to the State List, state governments hold exclusive power over 61 subjects of local importance. Key areas include public order, police, local government, public health, intoxicating liquors, agriculture, and betting and gambling. The concurrent list involves 52 subjects where both the center and states can legislate. If a conflict arises, the central law generally prevails. This list includes criminal law and procedure, marriage, forests, population control, and education. The 42nd Amendment shifted 5 subjects from the state to the concurrent list. The correct answer is option C, pairs 2 and 4. The 3rd Schedule deals with oaths and affirmations, not Rajya Sabha seat allocation. The 9th Schedule contains laws protected from judicial review, mainly related to land reforms, not the First Amendment itself. Let's quickly review the schedules of the Constitution. They cover everything from the names of states, salaries, oaths, and Rajya Sabha seats to tribal areas, the division of powers in the 7th Schedule, and the 11th and 12th Schedules for panchayats and municipalities. Next, we address the genesis of the doctrine of basic structure. We are asked to identify the correct statements. Statement 2, regarding the Sajjan Singh case, and Statement 3, concerning the Golaknath case, are correct, as they accurately reflect the Supreme Court's rulings in those landmark judgments. This slide provides a detailed analysis of the 4 statements from the previous question. Statements 2 and 3 are correct, detailing the court's stance in Sajjan Singh and Golaknath cases. Statements 1 and 4 are incorrect, clarifying the basic structure origin and reaffirmation. The incorrect statements are 1. As the doctrine originated in the case of Ananda Bharati case, not Shankari Prasad, and 4. As the Waman Rao case reaffirmed the doctrine, it did not set it aside. The correct option is B, 2 and 3. In question 19, on the union list, we look for statements that are not correct. Statement 2 is incorrect because the union list signifies exclusive federal jurisdiction, not cooperative federalism, which is associated with the concurrent list. Statement 4 is also incorrect, as the Supreme Court has full jurisdiction over union list matters. The correct answer is D, 2 and 4. The correct answer is option B. The 7th schedule of the Indian Constitution divides powers between the Union and the states through 3 lists: Union List, State List, and Concurrent List. These lists define the legislative authority of each level of government.